Well, for a closer look at both of the sentences today, we're joined by criminal defense lawyer Karen McArthur. She's no relation, of course, to Bruce McArthur. Let's talk about two of these sentences that will be handed out today. What are we watching for? Well,
we're looking to see whether or not the judges follow through on the Harper government's idea that they legislated that you can increase parole eligibility and make them concurrent. So we're looking to see whether or not Justice McMahon gives Bruce McArthur 50 years and whether or not the Quebec sentencing judge gives Alexandre Bissonnette 150 years, as opposed to what we would have had before the Tories were in power, 25 years.
Okay, so let's get a little Law 101 here, because they are a life sentence.
Life sentence,
but
absolutely.
The discussion is around the eligibility for parole, at which point they can go then to a parole board and say,
I'm rehabilitated.
Yes.
I'm rehabilitated. I'm not the guy that I was way back when. I can roam free on the streets. Well, not free, because you're still on parole and
That's
you're
right,
supervised.
because that sentence is still for life. You're still tied to the justice system in one form or another.
So what the public needs to know is when you're on parole, you're still supervised, and if you step outside of the rules that they impose on you, back you go to jail, to the big house.
Yeah. Okay, so now the issue around them being able to effectively stack them. What is in the judge's mind? As you say, relatively new, 2011 is when this law went into effect.
Well, the judge has to consider whether or not it's cruel and unusual. That's the argument that's being put forward in the Quebec courtroom. Alexandre Bissonnette's lawyer has called expert evidence on his prospects for rehabilitation. He's 29 years old when he effected this horrific crime. 2 years ago, he was 27 years old. Apparently, he is mentally unwell. That evidence was also put before that judge. And so the judge has to determine what is fit and proper. Sentencing is an individualized job. The judge has to look at each individual, look at their crimes, but also who the individual is and what they might be in the future. It's not just looking in the past, it's looking forward as well, and considering the community's interests.
So there's that community interest aspect to it, but that doesn't necessarily mean that the cries from the public in terms of throw away the key can be listened to. There has to be a dispassionate look at all the factors of the case, right?
Absolutely, and sentencing, as I say, is an individualized job. However, Parliament has enacted factors that must be considered in criminal cases, and more particularly so in those of murder. Normally, if you just did one first-degree murder, you'd be eligible for parole at 25 years. These two gentlemen, Mr. Bissonnette and Mr. McArthur, 6 murders and 8 murders respectively. It is a different task for the judge. And the Crown has waded in and said, look, Your Honor, for Bruce McArthur, we want 50 years. In the Quebec situation, the prosecutor waded in and said, we want 150 years. And it's up to these two judges in the eye of the storm today to determine what they impose for Mr. McArthur's horrific crimes and Mr. Bissonnette's horrific crimes. So we have to wait and see.
We've seen in the United States sentences that in some cases are literally thousands of years, not necessarily even for a capital crime, where the belief is the crime is horrific and the public has called for this, and this is the kind of sentence that's handed out. The Canadian system, though, has emphasized rehabilitation. There is punishment, there is public safety, but there is rehabilitation. Where does the rehabilitation debate go when you're talking about sentences of 50 years or 150 years?
I think if you take it to its extreme, it goes right down the toilet. It is gone. We are effectively back into the death penalty. If Mr. McArthur receives the 50 years, we know that means he dies in jail. If Mr. Bissonnette receives the 150 years, we know that that means he dies in jail. Whether or not it's at the hands of an executioner or just at the hands of time, the effect is the same. No chance at ever seeing sunlight again out on and freedom.
Go ahead.
I think in Canada we have a different path than the Americans. We're north of the 49th. We chose in 1976 to get rid of capital punishment. We also at that time effected certain changes. They have been dialed back over the years, but in effect as a country, and there was a great hue and cry and debate. I remember it well because I was I think I was 8 years old, living on Vancouver, probably watching CBC, watching Eddie Greenspan, in fact, talking about how we don't need to have capital punishment here. It probably inspired me to be a defense lawyer and to be right here today. But in the States, they have a real retributive justice sort of eye for an eye, vengeful approach in the justice system, which studies are showing doesn't really help.
And so, judges elected as well in the United States, which
they
puts
are
a
elected,
different kind of public pressure on them. And that's
political pressures are on them day in and day out. Here we have jurists and we have lawyers that battle it out and try to reach the appropriate balance. We are also fortunate here that we have the Canadian Charter of Rights and Freedoms, and one of the sections of our charter is Section 12, which promises that you will not be subjected to cruel and unusual punishment. And that is the very argument that Mr. Bissonnette's lawyer is advancing in that courtroom today, that it would be cruel and unusual to give a fellow who was mentally unwell, had been bullied as a youngster, who lost his mind when he was 27 and went into that mosque, to effectively give him the death sentence.
We've seen the push, for example, by a Conservative MP, James Bazan, to come out and change that eligibility, not in this sort of case by case, but to say rather than 25 years as the minimum eligibility, to make it 40. What do you think of that?
I can understand where he's coming from, and again, he is a politician, and to a certain extent, politicians need to pander to their community, to their constituents. There is an obvious disgust when you see stark crimes of horror that we're witnessing today. I certainly do understand what he's saying when he indicates we don't want to re-victimize the victims' families when they have to gear up and come prepared to a parole hearing, which is what in fact happens. So.
And is there something that you can see in that to say that before this maybe wasn't recognized, why not recognize the re-victimization? And we saw this when Paul Bernardo came up for a parole hearing, the parents of his victims saying it was as if it happened yesterday, having to relive all that 20 plus years later to go and to speak to the parole hearing like that.
I do see what he's getting at. I think advocating for a strict one rule of 40-year parole ineligibility is too far to the extreme, potentially as a political suggestion. And if I can make it here from my pulpit, there might be a threshold test that should be met before you can go to the 25 years or the 40 years. But I think fashioning a proposal such as he has, which is a one-stop, one-fits-all, is not the right political solution, nor is it the right community solution for Canada, who does in fact differentiate itself from the U.S. and its approach to justice, and it's something that we are proud of.
Karen, I want to thank you so much for coming in. Please hang around because we are still waiting for these events to unfold in two courtrooms, one in Toronto and one in Quebec City, and we look forward to hearing more of your insight into all this. It's been great having you on the show.
Perfect. Thanks, John.
Karen McArthur is a criminal defense lawyer speaking to me here in Toronto.